I'm your host, Bryan Hattingh, with you up until 8 o'clock. I'm quite sure you didn't hear me earlier. I'm always technologically challenged when I come in here sometimes. I was talking to the wrong mic. So there you are. Now you can hear me, and you're going to hear me up until 8 o'clock with my special guest, hopefully guests. But my silent guest is resisting hugely, but we're going to work on her because she's got lots to talk about. But at this stage is incognito. My guest who is with me is Gareth Cremen, who is the director of Ramsay Weber. And welcome to the show.
Thank you.
What caused you to choose law as a career when you were a young and aspiring, soon-to-be adult?
Well, I think at that point in time, not much was really known about law when you were growing up. But, when I was about 1 year, grade 1 or whichever the case may be, one of my very good friends at the time, his father was an advocate. And not knowing what an advocate was at that point in time, I was very curious.
Right.
And going around to his house, it looked absolutely marvelous. He had one of these fascinating wooden libraries with millions of books. So I sort of decided, well, let's venture into that avenue.
So, just to clarify, did you choose the route of being an attorney or an advocate?
I chose the route as an attorney.
As an attorney,
correct.
Yeah. So, interesting, I believe the changes in the law that is now going to allow attorneys to represent people in the Supreme Court, not simply senior counsels.
And vice versa.
Is that so?
With the Legal Practices Act, which has come into being, just not yet fully implemented.
Right.
So advocates will also be able to consult with members of the public directly.
That's a very interesting and rather large dynamic. I mean, it changes the playing fields quite considerably, doesn't it?
Tremendously, but what it also does is it opens up Pandora's box, because what it does allow for is for foreign lawyers who are not qualified in South Africa to come into the marketplace, get accreditation, and convert and start practicing law over here. So what you will find is an influx of lawyers coming in from the United States and Canada, all of a sudden flooding our market.
But aren't they schooled in different frameworks of law? I mean, we're Roman Dutch, aren't we?
We're Roman Dutch in that, but underneath the Legal Practices Act, well, let's take it back. You need to look at America versus Canada and all the other Commonwealth regions. The Canadian system and model is somewhat similar to ours in the basis, and basically, our Roman Dutch principles are somewhat similar, all the way down to family law, etc. Now, what the Act does allow for is that you take your qualification, all of your studies, your exams, you submit them through to the accreditation body set up, and they'll determine what subjects you need to convert, which they'll accept, what do you need to repeat through a South African institution, and rubber stamp, congratulations, you can now practice.
Interesting.
Yeah.
That changes a lot of playing fields.
It's not that simple, but it's really summarizing the whole thing.
That increases competitive play quite considerably. Interesting dynamic, because it's going to, I think, introduce a new spin of commercial perspective and commercialization onto the world of law.
It will, but what you'll also have is a lot of legal minds no longer calling themselves attorneys or advocates, but rather legal consultants, so as to break away and not fall underneath the realm of the Act or any other professional body.
Interesting.
So you are going to see a lot of movement when the Act is fully implemented.
Lots to talk about. Specifically, we were going to start the program, and maybe a lot of the program, and maybe all of the program, around the world of business rescue. A very interesting topic, an emerging sector, so to speak, that's been birthed over the last few years, and I think a vital component of service and perspective in the world of business. Let's just first, for the listeners, in case any of you out there aren't au fait with what business rescue is, do you want to give us a bit of a description of it at a high level? Yeah.
I mean, basically, by way of background and where business rescue came from is underneath the old Companies Act, the 1973 Act. It allowed for judicial management, or obviously for creditors, for a company also to work out a compromise with creditors. The problem is that judicial management was always seen as a system that never really protected the company. You never had a window or moratorium preventing any creditor from suing you for a debt. So when the Act was revised, they decided to put this whole notion of business rescue, which is not as advanced as Chapter 11 in the United States, but somewhat similar concept and procedure. And business rescue, in a nutshell, gives a company a working opportunity, a window space to work itself out of distress. But obviously, in order to go in, you need to be financially distressed. And there's a whole lot of requirements one needs to look at. But basically, it gives you a window of opportunity to work out of debt and to put a plan in place within which to pay back all of your debts to creditors over a period in time.
While still continuing to trade meaningfully and trade out of the debt.
Correct.
Yeah. Interesting dynamic, and I mean, obviously there's also, I would imagine, a look into good intentionality and good practice that was behind it. That these are companies that have fallen foul of good profitability, not really as a result of malpractice, but more as a result of just misfortune or industry conditions. Am I correct, or does it apply to across the board?
Look, it applies across the board. But that being said, a lot of companies have found themselves into difficult positions. One is because of lack of control by the directors. Two, bad business decisions across the board. A million factors could affect a company as to why they need to be placed under business rescue proceedings. But also bear in mind that business rescue in an ideal situation is perfect, okay? Bar the fact that there are many grey areas in terms of the legislation. But that being said, there's also a large amount of abuse over business rescue. And a lot of fraud on the go with fly-by-night business rescue practitioners.
Nice. Somehow that always seems to happen, doesn't it?
In every industry.
It's what one calls risky business.
Pretty much.
And that's exactly what you're listening to. The program is Risky Business, the heart of business, the soul of rock and roll. And we're a Good News Business talk show coming to you on Mix 93.8 FM. And if you would like to stream, do so on www.mixfm.co.za. With me in the studio, I have none other than Gareth Cremen, who is one of the directors of Ramsay Weber Attorneys. And with him, a very important person who is Kenzani Moyani, who is a senior account executive of Glasshouse Communications Management Pty Limited, who was the driving force to get this gentleman on the show. And hello, Kenzani.
Hello.
Welcome to the show.
Thank you so much.
It's an interesting thing. Communications management, public relations, such a critical thing for businesses. So often businesses overlook the merit and importance of it. Like a lot of industries, and Gareth, I'm sure you would attest to this, you get lawyers and you get lawyers, you get accountants and accountants, and you get PR people and communications people and communications people. It's such a critical component of it in terms of building reputation and reputation management and credibility. Why did you choose to go into this space? It's a lovely space to be in, but what got you here?
Sure. Well, I think it comes a lot from my childhood.
Really, yeah.
Being raised around a family that was in the media.
Yes.
I always found it fascinating. And as I grew up, that's something that I wanted to do and that I was passionate about.
Yes.
So I think it was just something that I was born with, I would say.
That's wonderful. And, obviously you would be selective of the sort of clients you work on behalf of. They've got to have a real story to tell. It's got to be a value proposition that's compelling.
Yeah, absolutely. At Glasshouse, we focus on a certain style of communication.
Yes.
And if we, find a client that's, relevant to that and what we look for, then we definitely choose in that regard.
Do you provide also strategic input to how they look to going to market and how they structure that?
I think every client is so different, and what we master in is putting strategies together that is suitable for that specific client.
Fantastic. Well, we're going to definitely give out your details later, and
Thank you.
I'm definitely going to visit you again a little bit later. You've got a great voice for radio.
Oh, thank you, Bryan.
There we go. So back to my primary guest here in the form of Gareth, and going back to the whole subject of business rescue, you mentioned in the break about the extent of litigation that's actually emerging in this space. It's quite surprising and quite sad to hear that here you have this whole initiative that's there to put things in order, and yet there's a lot of disorder that's emerging inside of it.
That's 100% correct. So what you tend to find is that business rescue is also being used to abuse the procedures, where companies are trading underneath reckless or insolvent conditions, and they realize that if the company is put into liquidation, there's a possibility of an insolvency inquiry taking place, where the directors will have to face those very awkward questions as to what really happened to the money.
Yeah.
So what they tend to do is put the company under business rescue, which doesn't allow for those inquiries to take place. So there's also a lot of litigation surrounding the business rescue practitioners. Number one, their appointment. Two is their independence, because strictly speaking, in terms of the Act, they're there to look after the creditors and all affected parties' interests. And by affected parties, we mean, it's a balancing exercise between shareholders, employees, creditors, and all other parties that have an effect on the business or interest in it.
It's so interesting when you look at how behavior in business has seemed to shift over the last couple of decades to a win-at-all-cost type of mentality, organizations getting excited about negotiating win-lose rather than getting excited about win-win. A sense of it's about me, it's about take. And in that, you can't create on-flow and you can't create a continuing and emerging economy when you are getting in the way of it, and you by hurting the suppliers that work for you, trying to screw them down to a margin level that actually isn't viable and isn't profitable, and yet they do it because they got to get the business. And in and through it starts to create wrong behaviors, and people pursuing the how much money is enough, and instead of looking to add value and looking to make a contribution to the whole social structure, it's about what can I get out of it. You take, for example, Richard S. Fuld, who was the CEO of Lehman Brothers at the time of their demise. The delightful man paid himself a $200 million bonus in 2007. Whatever justified that sort of payment? And look at what followed on 6 months later.
The ripple effect.
Yeah, exactly. It's very sad to see that. I mean, in the instances of business rescue that you've worked in, how many instances, or what's the sort of ratio of malpractice versus misfortune?
Well, I think let's first talk on the success rates. Not to digress a little from the topic, because I think that's the real starting point. So according to statistics in South Africa and according to CRPC records, it's approximately 80% of companies that go into business rescue fail. 80% fail.
Wow.
And there's a number of factors that actually, or the causing factor behind it. One is that they have the wrong business rescue practitioner.
Right.
Number two, there's lack of post-commencement finance or funding or capital injection to pull the company through the next, 3, 4, 5 months down the line to pull it out. And other factors are also, by the time they decide to put the company into rescue, it's sort of like taking a dead body to an undertaker and saying, well, please resuscitate it.
Yeah.
Sometimes they're far too long gone. And if you take it a step back and you look at proper turnarounds, a turnaround should take place from the time that you identify, in terms of, strictly speaking, all directors should be applying it, is can you pay your debts as and when they fall due and payable in the ensuing 6 months? That's the test really to determine whether you're financially distressed or not. And a lot of directors don't, because everyone always works on that notion, now I'm working on a massive contract. There's this massive contract coming in. I'm going to get a lot of work coming in the next 2-3 months. And that never happens. People run it sometimes on the smell of an oil rig. And in the UK, a study was done that all companies that go into administration in UK, equivalent of our business rescue, 75% come out that gauntlet clean, spotless, and 100% running again. Purely for the reason that they go in at the right time. They identify the need, they identify the risk, they identify the right business rescue practitioner, and obviously they take steps to put themselves into the proceedings over there.
What is an interesting thought as you were talking there that came to mind is how much of this actually relates back to ego, where the guys are, having to admit that you put your business into business rescue is almost a statement of failure, and guys would want to resist it right up until the very last minute.
I must tell you on that point, and you're 100% correct when it all comes down to ego. And we did the 7th business rescue in South Africa, and it was the only successful one. And I'm not saying that with a degree of arrogance by any means. And the reason why it was so successful was that creditors were given R1 for R1. And I've to date not yet seen any other company offer it. And what happened in that instance was we said to the directors at the very first meeting of creditors, stand up there and explain to him what happened. And the director stood up there and he burst into tears. And he said to the creditors in the room, guys, I'm sorry I let you down, but we were living a lifestyle. I had my penthouse in Camps Bay. I was living on a yacht, a 45 million rand yacht. We were doing helicopter flips for fun, and we abandoned the operation up in Johannesburg. And before I knew it, the business was going down. And when I found my other business partner, he was living in the Isle of Man. And when I found the senior manager, he was sitting on a golf course on the other side of Africa. And he says it was a company completely out of control. And he said to all the creditors, I can assure you you'll get R1 for R1. And what I have done is I've sold my 45 million rand yacht. I've sold my house in Camps Bay. I've moved back to Johannesburg and I'm renting a place. And all of my money is going back into this business. And I can assure you, you will get your money.
Wow.
Just take a bit of a haircut on an interest rate. And I can assure you I will work through it. So please work with me and not against me. And it was quite an emotional one. And there was a lot of hostility at that point in time from 2 or 3 of his major creditors, knowing that they might get paid only a year down the line. Literally 3 months later, everyone had been paid because they worked with him. He cut his salary for 3 months. There was no income coming in towards him. And there was a successful turnaround. But, it was one where we were boxing against the unknown at that point in time, not knowing what lies ahead and what lies behind and which creditors prepared to take you on. But that was a successful rescue. With that being said, what you also tend to find is that business rescue practitioners often get appointed by way of a resolution process. So business rescue can put a company under business rescue by one of two ways. Either by way of a court application, putting underneath business rescue, and anyone can bring that application. Be it the bookkeeper in a company who speaks to her boss and he says, no, not interested. She can bring an application putting the company under rescue. Any employee can. Any trade union, any shareholder, any affected party can bring that application putting a company in. So that's the one way, is by way of a court application. The second route is by way of a resolution, which is a problematic one because the board of directors elect that the company is distressed and needs to be placed under rescue. They go ahead and they source the business rescue practitioner and they find the guys in town. The question is, what are you looking for? Because if a company is left in the wrong hands of the wrong practitioner, either A, you lose your company, or two, it goes into liquidation, one way or another. So you need to take a step back and have a look at how the directors appoint. And more often than not, a strong director, and especially where his ego comes into being, and he decides to muscle, he will appoint a business rescue practitioner who doesn't have a very strong backbone.
Yeah.
And, he sort of controls the scenes and everything from behind the scenes. Because remember, when a business rescue practitioner takes over, in terms of the Act, he's supposed to conduct the full affairs of the business, but he steps into the shoes of the directors. The director then takes a backseat approach. He cannot make a decision on behalf of the company without the business rescue practitioner deciding what needs to happen. And that's why you need guys that are well-versed in turnarounds practitioners, and not a fly-by-night guy who's going to pop up overnight, has no experience. And I'm not saying that to discount anyone who is considering becoming a business rescue practitioner. But before you run into it, you need to understand the risks. And it's the same thing we say, is that whenever you attend the first meeting of creditors, if you're a creditor out there and you're affected, don't sit back silent in the room. You need to ask all of the awkward questions to that business rescue practitioner. I can assure you he's not your friend, neither is that company. Okay, although he's supposed to look after your interests. You say to them, dear Mr. Business Rescue Practitioner, what are your qualifications? Who are the professional bodies that you're associated with? 3 is, what is the size of your insurance in the event that you're negligent? It immediately puts him onto the back foot. 4 is, who appointed you? How did you get the appointment? How did you come to hear of the company in distress? Automatically it starts putting them on the back foot, and start digging deeper into the relationship sometimes, because, it's saying that when you tug on a thread, the more you pull on that thread, it's that, a little bit that'll break a camel's back or whichever.
So when we talk about a business rescue practitioner, is that very often a single person? Is it not a team of people? I mean, I would imagine it could vary in terms of size of operation.
Correct. So what happens is a court will appoint a business rescue practitioner, or jointly. It's not often you see a joint appointment, but, it's probably wiser to do jointly than singular. But often, you see a singular appointment, but what happens is the business rescue practitioner will then appoint a team to deal with certain aspects behind the scenes, but he is the appointed practitioner, and he'll simply outsource the work and put contracts in place for everyone else to support him. So you would have seen that, for example, in the likes of when Illarines went in. It was one person taking an appointment, but there was a whole team behind him.
Yes, because my question is that, is the emphasis on this person being technically excellent from a financial engineering point of view, or is there the element of having the business smarts and the business acumen to actually now make intuitive and sensitive business decisions?
Correct. So, you need to look at what is the requirement to be a business rescue practitioner. It's either someone of a legal mind, someone of an accounting mind, or someone in the business management world. And you need to demonstrate some sort of experience in running a business.
Yeah.
And that sometimes on its own is a problematic one, because, it doesn't mean that a person's best suited. As you said earlier, there's lawyers and there's lawyers, and there's accountants and there's accountants. It's the same.
Because somebody could come out of a very defined financial background, could have been a CFO of an organization, but they've really been confined to the finances and maybe a bit of operations of the business, not necessarily the running of the business.
100% correct. So just to give you an example, I made mention of it a little bit earlier when we were off air in that, but we've brought various cases against business rescue practitioners and challenged them in their personal capacities. And the Western Cape Court has now issued a cost order against a business rescue practitioner for committing fraud, amongst a million other things. And the gentleman in question was an accountant, registered to a professional body. And I mean, the fight doesn't stop there. It's still ongoing down in Cape Town, and one will see and watch that space. It'll be interesting.
Indeed. Once again, risky business. That's what you tune to here on Mix 93.8 FM. I'm your host, Bryan Hattingh. With me in the studio, I have Gareth Cremen, who is a director of Ramsay Weber, and they are attorneys at law. And we're talking at this stage about business rescue and all the implications and components of it. And alongside of him, and the air beneath his wings from a communications point of view, is the company Glasshouse Communications Management, represented by the senior account executive Nkenzani Moyane. And we're going to quickly just go to her. She's a reluctant but very talented guest here in the show who doesn't know it but has a fantastic radio voice. Nkenzani, talking about the world of PR and communications and marketing in general, very often companies, when they go into tough times, it's an area where they immediately look to cut costs, because the argument is, how do we measure the efficacy? How do we measure the impact? How can you show us the results? And yet that often is the very time when they should spend money. How do you deal with that with customers and advise them accordingly in respect of that?
I think all companies, especially when going through a crisis, they need to communicate, whether it's internally or externally. And you want to keep on building your company or your brand.
Yes.
So with marketing and communications, that helps in that regard. So we always try to advise them that that's the right thing to do moving forward.
And brand is such an interesting thing. You don't own it. It lives in the hearts and minds of the customer.
Absolutely.
So how you behave and how they experience you is what your brand is and stands for.
Absolutely.
And if you're not front of mind, brands aren't something that you turn on today and switch off tomorrow and then turn back on again when things are better.
Yes.
There's got to be the sustainable view, the sustainable front-of-mindedness. So important. Huh?
Yeah, and if I can give an example, Coca-Cola.
Yes.
I mean, they don't need to ever advertise ever again. But they keep doing that, and that helps with keeping the brand alive.
I remember, and I don't remember the details, so I'm not even going to try to, but there was a time where there was a whole little, there always been the Pepsi-Cola Coca-Cola wars, and it's been interesting how when Coke stopped spending certain money, Pepsi increased and increased penetration and consumer purchasing and vice versa. So, one can't ignore the merits of it.
Absolutely not.
No. And it's just one last question, and then I'll move across to Gareth. When looking at organizations, so it's one thing when you're talking about brands like a Mercedes-Benz or brands like fast-moving consumer goods, where you talk about Coca-Cola. When you move into the services space, like the field that Gareth comes from in terms of attorneys, you're talking about something that's intangible, something that's soft, something that's, and also hard, but that is more difficult to build a brand around. What are your sort of rules of building that brand and going to market with that?
Well, I mean, as I mentioned earlier, it's strategizing.
Yeah.
And obviously we'd have to target the market that is relevant to that company, being Ramsay Weber. So we'd focus on the avenues that would be relevant to them.
Right.
So that's how we structure it.
Awesome.
Yeah.
Thank you so much for sharing that.
Thank you.
Gareth, talking about business rescue, is there a sort of entry-level requirement in terms of size and critical mass of business, or industry type or industry sector, or does it apply to anybody? Could a three-man business go into business rescue if they wanted to?
It applies to all companies.
Right.
So be it whether you're a closed corporation, a proprietary limited or incorporation, whichever. I mean, you would be subject to the Act anyway.
Interesting. And do you see instances of smaller companies putting their hands up?
You do. One of the problems of smaller companies going into rescue is obviously finding a business rescue practitioner who does not charge senior practitioner rates.
Okay, I was just going to come to that.
So obviously it looks at, depends on the size of the debt and the amount of debt. So, I mean, if you have a look at a closed corporation, one of the questions, for example, we've always said that pretty much, you are entering into a bit of a tsunami of business rescues to follow in the ensuing months, based on stats from various economists. But one of the sectors which has fallen, as at last year they started tumbling, was the safety clothing sector. And, one of the problems over there was that they found themselves in debt for up to R500,000, which is not a big amount in the greater scheme of things. But by the time you have to put a business rescue practitioner in there, and by the time you need to inject capital, the question which you always face with is, well, if I start up the company again from scratch, it would require 100, 200,000 rand to get it going again. So why would I want to inject, 100, 200,000 rand into the business to try and offset against some of the debt? It's always that balancing exercise, and is it viable and worth your while? Does the means meet the end?
So is the business rescue practitioner expected to raise and put capital in?
The business rescue practitioner must explore all avenues and possibilities, and that's why I say it comes down to the qualification of the BRP and his experience. But a proper BRP will look at the business, look at the problems faced, look at debtors, creditors, bank balance, look at your marketing avenues, which we were talking about earlier. And a good PR exercise will always keep the company going, direct communication with clients. But part of his exercise is a bit of a tricky one, because you can't just apply pure accounting terms. You also need to look and be, pragmatic, and also look at the business from other avenues and say, what does the business need to keep that heart pumping? What is the problem is if we don't, you'll lose all your IP. And IP, I don't mean your intellectual property, it's trademarks and that. But really the IP, which is something which every corporate forgets, is really the heart and the backbone of the company.
Absolutely.
And that's from the lady sitting in the front reception to the management to sales. And if they walk out of the business, there goes clients, there goes the heart of the company. And that is the true sense of true IP in a business. So part of his exercise is he needs to look at all of that and try and retain them in the business. And part of his job is also to find working capital, either from existing shareholders or by way of post-commencement finance, or by way of, someone else prepared to inject capital or convert debt to equity. Million scenarios.
So here's a spin, and I'll be interested to see what the legislation on it is. What is the potential for the BRP to say, look, I'm actually not risk averse here. I'll tell you what I'll do for my fees. I'll take a 10% stake in the business. You don't have to pay me money, but I'm going to look at the upside, and in that they've got a vested interest, they've got skin in the game, and all the more reason why they should make sure that they actually get to turn the thing around.
That does happen. I'm saying that, but it's a clear conflict of the act, because
I was going to say,
as a business rescue practitioner, you need to be independent, and you cannot have a conflict of interest. And on that note, there was a business rescue practitioner removed from his appointment for doing that very thing down in KwaZulu-Natal. He went into a business, saw a fantastic business opportunity, realized, he couldn't be the forefront of it. So he says to his father-in-law, by the way, please buy that business, I'll be the BRP. And by the way, to his brother, why don't you also take a stake in the shares, and we'll, pull a deal on the side. And then R8 creditor decided to challenge all of them. Whereas it got to the point now where that business rescue practitioner will never take another appointment in town. His reputation is so badly tarnished because they had a good PR team behind them, to say that this is what these guys have done in town, and this is why they've behaved badly, fraudulently, and a million other things.
Yeah, sort of the statement like, I've got a very firm and clear set of ethics and values. If you don't like them, I've got others. It's a challenging realm, because on the one hand, that in principle that could be a really creative and a really sensible way to do it, because if you've got skin in the game, you're going to make your best effort to build sustainability and to build turnaround. But it goes back to what you're saying, it can easily be inappropriately explored. Going back to that very important element about the IP, so many businesses today are people-centric and IP-centric businesses. We're moving into the digitization age, and we're moving into a whole new space where the complexity of talent is increasing, and yet the availability of that talent is becoming increasingly rare. We're seeing the emergence of new careers, new disciplines, a world of disruption and innovation, that there are jobs that are going to be in existence in 5 years' time that aren't even thought of yet now. And so the whole challenge that we're facing, and we see it across Europe and in the UK, is this diminishing pool of talent, not increasing pool of talent. So the moment, when these things happen, quite often in the build-up to the business rescue, the staff are already talking about it. There's corridor talk and rumour mongering. And in the absence of clear and effective communication, people will make up their minds for themselves. Your best talent's the most mobile talent, and they're going to be the ones that are going to exit. And people on the outside who might know or have a sense of what's going down are going to target them and going to hunt them out of there. What can you do as a BRP and in that space to create a retention scheme and a way of holding on to the talent?
It's a difficult one to answer immediately, but I think you first need to look at, the BRP's role when he takes command of the business, and I think the whole thing of it is to be transparent with the employees directly. and give them the reassurance as to what exactly your role is. And, you're supposed to have a meeting you have to, in terms of the Act, have a first creditors meeting and equally have a first meeting of employees, whereby you sit them down and say to them, guys, the company's gone into business rescue. This is the procedure. This is who I am. And you run them through the requisites in terms of the Act, the whole requirements and all the disclosures. Now, in terms of retaining the employees, what a very wise business rescue practitioner will have to do is explain to the employees that there's no guarantee down the pipeline, depending on the situation, that they may get paid. But explain to them the ranking of claims and and as to how an employee ranks. So just to go through the ranking of claims is, in a business rescue scenario, the business rescue practitioner is always guaranteed his fees. He's always first in line, standing at the helm of the company and managing it. So I suppose it was the incentive to get them to do a proper turnaround. Second in line would be all of the employees whose salaries are due after the commencement of business rescue.
Okay.
So the employees have got some degree of security, but not for any salaries which haven't been paid prior to. Thereafter, you would get your secured lenders, the companies that have, given lending or loans, whichever the case, after the commencement of business rescue. Followed behind that would be unsecured lenders and all loans after the commencement of rescue. Falling directly below the line is all of a sudden the ranking of claims prior to business rescue proceedings, which fall in is secured lenders or creditors before business rescue, claims that of employees before rescue, and unsecured lenders prior to rescue. So once you've explained to the employees where their status and where they stand, you would have to say to them, there's no guarantee you would get your money prior to the commencement of rescue. You might get a cents in the rand offer. But moving forward, you would be second in line to receive payment in the event of the company, going under liquidation or whichever the case may be. But you need to assure employees to a degree, say to them, look, we understand that payday is in 3-4 days' time. These are the immediate steps that we've taken to secure your salary immediately, so you can meet your debts as and when they fall payable. And be honest and transparent with them. I mean, some employees, approach you and say to you, well, look, I've got another job elsewhere. Is it best for me to go? A business rescue practitioner can secure their appointments. He's supposed to. And obviously ensure their jobs and their livelihoods are kept at stake because they are the heart of the business. And the problem is if they don't do that exercise right, and it's happened to a number of businesses where the business rescue practitioners have not taken control of the business, they've not given the assurance to the employees, and quite correctly as you stated, is that all the key individuals were poached by competitors in the industry, and they walked out of the business, and by the time you were done, you were left with a handful of directors and not enough loyal servants who understood the business better than what the directors did. They weren't the hands, the eyes, the feet on the ground.
I've just had a brilliant idea of a fabulous service opportunity to provide into that space, where you change the lenses that the individuals, the key talent and the talent in the organization look at the situation. And what you do as the BRP is to model a portfolio enhancement journey for them. In other words, to say these individuals took a step of courage, they committed to the process of turnaround, these are the additional challenges that they had to work through and face, these are the milestones and measurements that they helped to achieve and reach, and it can be used as a career and CV enhancement, in that they seem to have actually stayed with it. So even if the business doesn't actually achieve its outcome, they can go to market with an enhanced resume that shows great levels of commitment, willingness to go the extra mile, to take a bit of risk, and to muck in and make it work.
I fully agree with that, and I like the idea.
Great, so we'll talk about it offline. But no, seriously, I think so much of these things are about changing the way that people are looking at them. Perception is such an important component to how people apply their behaviors and how they apply their decisions.
Perception is very much important, and also the key of transparency.
Yeah.
If you're shutting a person out and you're telling them what they need to know, versus what they want to know, always creates a bit of a problem, because it doesn't put any trust in the person who's sitting at the helm. And we always say to guys, be as transparent as possible. Not one that chases everyone away and they run down the street, or whichever the case. But you can't sing them a song and a tune that you're never ever going to fulfill, or a line you're never going to walk.
If you think about it from the tragic situation of people who become cancer sufferers, really imperative that the doctor gives them the reality check, but at the same time can present what hope there is. So provided you can give people meaningful hope against a reality check of where it is, then people can actually frame themselves and their perspectives in how they move forward in respect of that. And if you, as an executive, can demonstrate integrity in the difficult times, you'll most definitely be trusted in the good times.
But it also has a lot to do with your mannerisms.
Yeah.
And I think, and I'm digressing off the point of business rescue, but you take, for example, underneath America, and research has shown that doctors in America who spend less time with their patients after surgery and who are rather abrupt and just brutal and to the point end up being sued down the line. Whereas doctors who are negligent in America don't get sued very often because, they spend the additional 3 to 5 minutes with the patient and they'll cut off his leg by mistake and they say, hey, I'm so sorry for cutting off your leg. By the way, you have the other one and, I've got insurance and claim. And they turn it into a bit of a joke and the patient's upset. They don't end up seeing that doctor. It's the most bizarre situation, and studies have shown that. Insurance policies have shown that, over the years. You need to look at the mannerisms and how much time you spend with the person. So the same holds true with the business rescue practitioner. Don't just shrug a creditor off when they ask you questions, because they're very much bleeding, and the ripple effect can start on them. I mean, for example, rumor had that one of the companies underneath the Ellerines Group was exposed for 400 million rand unsecured. So obviously the ripple effect of a cents in the rand offer, you're next in line to tumble. And the same sort of thing of you. So as a business rescue practitioner, when you become, abrupt, short-handed with a creditor and you don't listen to their concerns, I can assure you the creditor will come after you if you make one slip up and you do not dot that I or cross one T. He will come after you somewhere down the line. And the same with the employees. It comes down to your mannerisms and the way within which you deal with people and the complaints.
Interesting story. There was a lawnmower hire company in the States, and I've shared this before, I think, on radio, was that evidently there are a lot of lawnmower hire companies in the States, and evidently there are lots of accidents. So I don't quite know how people injure themselves with lawnmowers, I can imagine, but they're things you shouldn't do, And they reduced their amount of claims by 1,000% by saying, sorry. That's all they did. They said, we're sorry. And they reduced their claims by literally 1,000%. I mean, that is not immaterial. That's super material. And
I think it goes back to the notion that people want to be heard, and not just want to vent with someone. And we've always said it with every company, when you deal with consumers in the forefront, set up a dispute resolution process. And I don't mean say to them, by the way, there's the Arbitration Foundation of South Africa, will see you, in legal proceedings. The right way is for you actually to put someone as the forefront, and when the consumer has a complaint, let someone that can sit and have coffee with and scream it across the table. And the guy's so nice and polite and back to him says, look, I'm so sorry, I couldn't help you because of the following reasons, and shrugs him off gently and politely. It makes the world of difference because the consumer knows that he was heard. But I mean, that's a different discussion in its entirety.
Absolutely. You tune to Risky Business on Mix 93.8 FM. I'm your host, Bryan Hattingh, and with me in the studio, I have Gareth Cremen, who is a director of Ramsay Weber Attorneys, and alongside of him from Glasshouse Communications Management Pty Limited, we have Kenzani Moyani, Senior Account Executive, and we're talking, amongst other things, about business rescue and organizations going through significant levels of change. And on that subject, significant levels of change, mergers and acquisitions is another space that has a lot of change and a lot of fall off and a lot of failure. I mean, the statistics globally are horrific. Over 75 to 80 years of M&A, up to 70% of them have either failed or failed to give a return on capital invested. And so much of it has been caused by leadership, cultural and people disparities that haven't been managed or planned for. And yet, the learnings are there, the case studies are there, and yet the guys make the same mistakes over and over. Is that a component of potential in business rescue, that you sell out the business? And
it is. It very much is. But also one of the pitfalls to mergers and acquisitions, which at the moment should be an absolute, massive. It should be a massive area in South Africa. But one of the pitfalls is often the company acquiring another entity or a competitor does not do a proper due diligence.
Right.
And by the time they buy the business, they were sold, the company was worth, maybe let's use a small example, a measly 4 million rand, but a lot depending on the size of the company buying it. And when they buy it for 4 million rand, the liabilities are in excess of 7 million rand. And we always say to companies, don't buy shares, buy the business.
Yes.
Break away the two. But underneath business rescue proceedings, coming back down to that point, there's a lot of companies in town, a lot of private individuals, a lot of investors, equity houses, etc., that are always interested in buying a business in distress. Buy it for 1 rand or whatever the price is and flip it, put working capital back in. So it is a massive one on its own. For a company that knows that the market is always getting smaller.
Yeah.
Under the sun, and you've got a competitor who's gone down, but he may have fantastic clients, or something he may have which you don't. So what you want to do is end up buying or taking across employees or key individuals. So it very much is a big avenue, and I think there's a lot of talk around it at this point in time.
And I think that companies need to pause and reflect on it. So often when the companies are getting ready to do an M&A, in the build-up to it, particularly if they're listed, there's this whole thing of non-disclosure. I mean, you could affect share price. There's a closed period and all these sort of things. And once again, there's no communication internally. And in the absence of communication, we go back to and management always invariably under-communicate. They never over-communicate. And often they might miscommunicate, but they seldom communicate sufficiently, and often the horse is bolted before by the time you get round to it. But part of the problem is so that you've now gone through all the dancing, the courtship, whatever, and then you get to the time of formal due diligence, offer pending due diligence, and there's the legal, as you would know, and there's the financial, and then you mention the human capital or cultural due diligence, and the question is, well, how long will that take? And when you tell them, it's like, wow, no, we haven't gone aboard that much time. Can't you do a little, like, sort of just a light version of it, and just like a quick litmus test and see if it's cool, and no, it doesn't work that way. I've seen due diligence reports across the board, sort of 6 inches deep, and they've got a one paragraph that says we shared organograms, yay, well done, and yet they're people-centric organizations that could easily fall over. And big players have got it wrong. Look at the impact of the way that the Hewlett-Packard Compaq merger was done, and massive shareholder loss, value to shareholders lost. And the view was simply, oh no, we're in the same business. Yeah, in the same business, but you way different companies,
different cultures,
completely different cultures. So I mean, is that something that you advise clients on and get them to pause and breathe and say, look, let's check this out?
Well, look, we always say to companies, go look at the environment, look at the people, look at the cultures, do proper due diligences.
Yeah.
And don't just leave it purely at an audit base.
No.
You also need to look at the legal component. But the question is, how far do you look into a business? And there was a fantastic case, or it was actually a very sad case, but a fantastic one by the Competition Tribunal, which involved a company buying another company out, doing a merger and acquisition, and they didn't do a proper due diligence. And a few years later, the new shareholders had found themselves before a full-blown competition investigation into the affairs of the business, because the previous owner was still the consultant for the business, still running around to regional forums, and he was colluding with competitors in the industry. And the Competition Tribunal left a lot of questions open, and one of the questions left unopened. Anyway, to me, get right to the end result. The end result, really, what the Commission's ruling was, had the guy not passed away on the morning of the inquiry, the truth would have, unfolded itself.
Yeah.
And that was one of the problems over there. But, we always said to companies, had you done the due diligence in the beginning, more than likely something would have flagged itself. You would have been able to take precautionary measures and steps and do the relevant inquiries, build in the relevant indemnities, etc. And when you buy a company, what do you look for in the company? It's all good and well putting a restraints clause in there, but surely somewhere along the line, indemnity provisions need to be built in. Who are you paying the money to? Mm-hmm. And what happens if you do find yourself before such an investigation? Who do you go after?
And just taking it back to the human capital and talent and leadership side of it, there are different scenarios. So if for example in an acquisition, I'm as a big company buying you as a little company, and an owner managed company, there are different profiles of risk. So if you're selling to exit, then what I first need to do is to check how dependent on you is the brand, is the revenue, the pipeline, the business as a whole, and is that transferable, and if so, over what period of time? And there come the suspensive conditions according to the transference of that IP, those relationships, whatever it might be. Alternatively, if you're looking to stay, now there's a whole lot of other dynamics. What are your intentions for the business? What are my intentions? Am I going to ring fence you and let you run and continue as the branded entity that you are? Or am I going to roll you up into my brand, my business, and merge you into it with the cultural disparities that are going to be there? And you've got to start looking for those. And also, alternatively, is this a white knight situation? Are you in desperate trouble and we're coming in to buy you? And why is it a white knight situation? Didn't you manage it properly? What was wrong there? Going back to the business rescue type of thing. Yeah. Is it a collaborative acquisition? Is it a contested one, or is it a hostile one? Each of those bring with them different profiles of risk, and you need to look at that and manage for that.
Yeah, I mean, once there's a culture inside of a business and there's a radical change, inevitably you're going to end up with doom down the line. And people don't like change. Everyone says change is good. But the problem and the reality of it is that if you have a conservative style of managing or a very aggressive style, and the company which you're acquiring and the employees are not used to it, inevitably they're going to be unhappy and end up leaving down the line.
But you see, the thing here is that what so often happens in the acquisition space, particularly when it's left simply to the investment guys and the legal and financial guys, and no disrespect to them, where they see the synergies, they see the alignment, they see the potential increased EPS and all that the rest of it might come with it. What they don't often do is to manage the disparities, or even look for the disparities. And the fact is, there will always be cultural disparities. So it's not about the fact that there are disparities, you shouldn't do the deal. There might be instances where there are showstoppers, but it's not managing for and not being aware of them that creates the problem. So if you can take and look at the disparities, map the two cultures and look at them and realize that in many instances, particularly if it's a sizable acquisition in terms of numbers of people, that you've got culture 1 and culture 2. You're now going to have culture 3, because it's not going to be the same one there. So where do you find the alignment? What are the common areas of ground in terms of price of admission, values and behaviors inside of those businesses? And how do you make people aware of the sameness rather than the difference to enable you to collaborate and work together?
You talk about collaboration. I mean, collaboration is key. Part of the thing is, don't break a culture immediately.
Yeah.
If you're going to try and install your way of doing business, understand the needs of the people and do it over a period in time, and do, small implementation and small changes. Unless there's a need sometimes for a radical change, and sometimes there is, because often you find the workforce is lackadaisy, and, it sort of shows, and that's why a company was distressed. So you need to look at the factors, the underlying problems, and try and, deal with them in the appropriate manner. And not, all of a sudden implement harsh employment policies and HR policies, and you will do this, and these are the hours you're going to work, when they were used to working flexi time. It becomes a difficult balancing act, and I think it's one of the things which a lot of people discount in its entirety. I think everyone looks purely at, which sometimes rightfully so, but they always look at what is their, return on investment. Does it make financial sense? But at the same time, that's one key component. Keep the employees happy, and you will make your return on investment worthwhile, if not double it.
And be as transparent as possible around the intentionality. So if I'm buying you simply to buy profits or to buy customer share, or just simply to buy or to take you out because you're actually in the way, then it's a whole different movie. You tune to Risky Business on Mix 93.8 FM. I'm your host, Bryan Hattingh, with you up until 8 o'clock. And in the studio with me, I have guests in the form of Gareth Cremen, who is attorney at law and director of Ramsay Weber, and also representing Glasshouse Communications Management, Kasani Moyani, who is a senior account executive. And we're talking about subjects of mergers and acquisitions, business change, business rescue, and all sorts of things. Here's some historical facts. 1909 on this day, Kinemacolor was the first successful color motion picture process and was shown to the general public at the Palace Theatre in London. 1914, HMHS Britannica, sister to the RMS Titanic, was launched at Holland and Wolff Shipyard in Belfast. 1935, Robert Watson Watt carried out a demonstration near Daventry which led directly to the development of radar in the United Kingdom. And in 1966, the Apollo program, launch of AS-201, the first flight of the Saturn IB rocket. There we go. Interesting things. Siemens turbines to run SA wind farms and generate 360 megawatts. And Siemens will supply and install turbines for a 9 billion rand, $770 million project to build 3 wind farms in South Africa with a combined capacity to generate 360 megawatts of power. South Africa's most advanced economy is battling chronic energy shortages that are pushing its government to seek alternative sources of energy from its fleet of coal-powered stations that take much longer to build than wind farms. The German industrial group signed a contract with Mainstream Renewable Power, a Dublin-based clean energy developer that is planning to build a $1.9 billion solar and wind electricity project in Africa. Mainstream said construction will begin on the 3 wind farms this month. The new energy project aims to produce 700 to 900 megawatts of electricity in the next 3 years, with wind and solar projects already earmarked for South Africa, Ghana and Egypt. The World Bank estimates electricity outages on average cost African countries around 2.1% of GDP, with current output only meeting half of demand and 70% of the continent's population living without power. South Africa faces years of power shortages as engineers step up maintenance to overhaul power plants run by state-run utilities, Eskom that have been run too hard over the years to compensate for a lack of new generation capacity. There we go. So that's good news, and let's hope they come online really, really quickly. So getting back to our conversation and the world of work and the world of law, talking about this whole shift, going right back to our original discussion about attorneys being advocates and advocates being attorneys, and foreign legal practitioners coming into the country and being able to practice. It opens up a whole new competitive play, and does it not mean that legal practices are going to have to think differently about how they go to market and how they secure and protect their income streams and their client base?
Most definitely. Life begins when you're out of your comfort zone. And I think in this case, I think it holds true for almost every law firm and every advocate in town.
Yeah.
It'll be an interesting one to see, because you will always see rebels breaking away from the Bar Council, which obviously needs to change in due course. But you will see rebels breaking away, guys cutting prices left, right and centre. So you'll see a lot of activity.
Does it mean that attorneys can then join the bar?
What it does is it allows, there's a whole lot of different avenues, but basically what it does allow is for attorneys in that to represent clients all the way through to the high courts and that, and to obviously Supreme Court. The problem that comes in is that judges typically do not like to see an attorney appearing before them. And often, a judge will give an attorney a far harder time than an advocate. Obviously, there are different reasons and different thoughts in that behind it. But what you will find is advocates breaking away and not relying on the instructions of the attorneys. 80% of all of the work is given to 20% of the advocates at the bar. So it's a very grueling position and a very tough job, because, many are well-known advocates over the years have died, absolute paupers with not a cent to their name.
Is that so?
Correct. You can look at from the likes of the late Ati van der Spey, who actually started the movement many years ago to try and create a rebel bar, and to, try and allow advocates to, get instructions direct from members of the public. At that point in time, he was heavily frowned upon. Rightfully so from our side, but he was always a rebel, and always fought a good cause.
Interesting dynamic. Are we not talking about an application of different sets of competency? So attorneys are excellent in the research and assimilation of information and legal practice and all the rest of it to prepare the advocate to argue the case.
Ideally, that's the role behind a good attorney, and that behind the scenes is really the guy that puts the paperwork, sets the case up to where it needs to be. And advocates always seen as your specialist in the High Court. They take the time to sit, research, prepare arguments, and advise under the sun. It also, creates a degree of independence, in the sense that attorneys are often tied into the matter emotionally, because you're fighting the fight for your client. You're tied and you walk their lines. You believe in their case all the way through. And the advocates take it a step further, and they take the emotional aspect sometimes out of it, which makes argument a lot easier, cleaner, directly to the point. So there is very much a need for it. I've always believed that the split bar system is very effective, unlike America. But it's worked wonders in, obviously in the UK.
Question I've wanted to ask on air forever. Okay. Let's move to criminal law. Okay, just for a moment. How does an attorney and counsel reconcile a situation where they know that their client is actually guilty and they have to defend them? How does it affect how they approach it and their ability to, and in turn, how they feel about knowing, for example, if they secured a dismissal for a murderer or a rapist? It's such I've always wondered how philosophically they approach it.
I think it pushes the moral boundaries, and I also think it depends upon the person in question. But if you know your client is wrong, the right thing to do is you're not going to represent him to the best of your abilities. And the best thing is rather to recuse yourself if you know that he's completely in the wrong, or if you know he's in the wrong, speak to him, and say to him, look, you're completely in the wrong in what you've done, and be honest and frank with him, and say to him, look, go and negotiate for less of a sentence, instead of fighting and pleading your innocence when you know you're as guilty as sin all the way through. But it comes down to, I suppose, moral fibre at the end of the day and what you really believe in.
Oh, such an interesting dynamic. I mean, do you have that facility in South Africa like you see in Law and Order and various other sitcoms of going to the DA and arguing and debating around and bargaining, a plea bargaining and doing that sort of stuff? I mean, how much does that really happen?
But by the DA, you mean the District Attorney, yes, not the Democratic Alliance.
Exactly, yeah.
Look, it does happen in South Africa where often you have the attorney or through the means of the advocate or whichever will go and speak to the public prosecutors or the senior public prosecutor and negotiate for less of a sentence, or enter a plea of guilty and chat to them and see what they're prepared to do. So it does happen often, more often than not. Just you don't often hear about it.
Yeah, interesting dynamic, and gosh, I've always wondered how that plays out, because it's a really difficult one. Particularly if, for example, they haven't been fully transparent with you, and they've protested their innocence, and then through the process it becomes clear that they're not. And here you are facing reputational damage as a senior counsel or as an attorney, where you've gone into defendant and you've gone out on a limb for them, and you've discovered, actually, hang on, they've told you a whole pack of lies. It must be quite challenging.
I'm sure it is. I can't really comment because I don't do criminal law.
Okay,
but I'm sure it does at some point when they do find that out.
What's the spread of civil/commercial attorneys in law to criminal?
I think being a criminal attorney is tough because the simple notion is that there's not really any money in criminal law, and I think if you're lucky you might get a high-profile case once in a while.
No names mentioned.
No names mentioned. Down the line, but generally there's no money in it simply because the man on the street, and the reality is that attorneys in that have outpriced themselves, and that's obviously where the Legal Practice Bill comes in to regulate pricing again. Because genuinely speaking, the man on the street has a dispute. You can't afford an attorney today. And always the advice that I always give to your clients and that, and to potential, litigants down the line is, always be open, honest, and frank with your attorney, and explain to him your financial position, which a lot of people don't. They walk into the attorney pretending to be a man of means, and they say to the attorney, I've got all of this and money in the background, and to an attorney, it's music to their ears generally. And the one thing which we always say to the client is don't litigate for the sake of litigating, and look at it from a twofold approach. There's always the commercial sense, behind it, and, obviously, the other side of the coin where you want to look at something and say, but I want to prove a point. And at some point in time, you look at commercial versus that and say, well, does it make sense to litigate? And more often than not, no. But as I say, always be honest with your attorney up front and explain your position.
And by the way, if it's a Supreme Court matter, you're going to wait 3 years before you get your first hearing. So factor that in,
If not longer.
If not longer. We have come to the end of our show. And firstly, really, Gareth, thank you so much for coming on air and sharing with us, and some really valuable insights and perspectives particularly around business rescue. And thank you very much, Tanya, for coming on and sharing a little bit with us and taking that bold step your first time on radio. Well done. I think you did fantastically. You're very well done. Would love you just to share your contact details. Gareth, you first, if you would, if people wanted to get in touch.
Sure. They can either go to our website, which is www.ramweb.co.za, or they can phone our switchboard 011-778-0600. And obviously all of our details on the website and all by way of our switchboard.
Fantastic. And Kasani?
Our website is www.glasshousecommunication without the S .co.za, and they can get all the details there. And our Twitter handle is at GHCMSA.
Fantastic. Gareth, Kasani, thank you so much for coming on air.
Brian, thank you.
Wish you continued success and go from strength to strength. All good things. Thank you. And me signing off, as always, to say if you're not with the ones you love, then love the ones you're with. Take time to show and tell the ones you love just how much you do. And take some time to love yourselves. Remember that charity starts at home, and importantly, take care of yourself and drive safely, and be found guilty of many random acts of kindness this week. We're going out with simple minds. Don't you forget about me.